Some kids at a house got upset. They did the right thing. They called the police. The police came out. Totally a false alarm. Found absolutely nothing. How this is relevant to the killing of Ahmaud Arbery or the guilt or innocence of these defendants, the state is unaware, especially those types of reports. So I wanted to make the court aware of this and ask that this be excluded. Thank you.
Morning, Judge. I'm holding in my hand a document provided to us by the state, certified copy of all of the 911 calls over January 1st, 2019 through February and beyond. We've just gone and gotten the CADs of all these calls, Judge. That's it. State gave us this information. I'm not sure what Ms. Dunikoski's talking about. This is the, I'll approach if you'll let me.
Explain to me how the two connect.
Yeah. This is a report of the stack of papers that we just went and actually got the reports of. So Ms. Dunikoski gave us this list. Incident number 1, neighborhood patrol on 1/1/19. Number 2, shots fired, 1/1/19. Number 3, neighborhood patrol, 1/7/19. Number 4, citizens assist, 1/26/19. And the list goes on and on and on. This was generated for the state, who gave us a certified copy of it in reciprocal discovery. Now what we did, Judge, is we went to
we just got that, basically.
Okay.
It's dated.
Okay. Well, this is the certified copy that I guess they gave us in trial. But this list of cases is a list of cases that's been about the neighborhood. They just pull all the 911 calls in the neighborhood. So we've pulled the CAD reports for that. And we had a lady come in and testify.
Police reports associated with the
CAD reports, Judge. CAD reports. Those are the computer automated dispatch report that comes out, and there's maybe other reports with some of them because they're more detailed.
I'm trying to get on the same page with you. You're showing me the document that you have, which is the CAD reports. What I
I'm
thought.
just showing you a list. That's all this is a list.
Okay.
Can I show it to you?
Let me just make sure I understand
Okay.
what's out there. Because what you were saying was there were the CAD reports, and these are police reports associated with the CAD reports, but this is a different list.
Yeah. I'm just starting from the beginning. We were given a list of incidents where the police were called in Satilla Shores. Okay. This is just a list. It's a 6-page list of all the 911 calls, just noted by incident number, the nature of the call, the area, the reported time and date, and the disposition. And it just lists them one by one, and it goes from January 1st, 19. This list goes actually all the way through May 25th of
The document you
2020.
have in your hand was provided in discovery. This was, explain to me what that is again. That's the
Yeah,
cert.
this was provided and I believe exchanged in discovery, which is just a list of all the 911 calls. Okay. I guess on November 10th, the affidavit of custodians of records was signed by Cherry Bachelor, who testified in court. And that's dated November 10th. All right, and I think Ms. Bachelor was used to get in specific calls and things like that that became relevant to the case. So in terms of knowing about these cases, the state has known about these cases throughout the period of reciprocal discovery. What we have said is that we intend to demonstrate that there was a lot of concerned neighbors in the neighborhood of Satilla Shores. There was a lot going on. There were a lot of extra patrols. There were a lot of extra watches requested, and there were a lot of suspicious persons. And our goal is simply to note the location, the house that was called, that made the phone call, the date, and the nature of the call. Either suspicious person, or neighborhood patrol, or extra watch. These are things, to a certain extent, Officer Rash has testified about. He said, I've patrolled that whole neighborhood. I've gone up and down the streets. I've done extra watch. We've talked about the nature of a suspicious person's call. We've had evidence about that. We've had what neighborhood patrol is, what extra watch is. And so all we're doing, and Ms. Dunikoski, maybe we should have talked before, but what we are seeking to do is simply establish that there is a high volume of suspicious person calls in this neighborhood, and that there is a lot of extra patrolling going on in this neighborhood, and that a lot of that then bled into the Facebook page, which we'll deal with through our witnesses. But what we're seeking to do is tender these documents into evidence, not have them go out with the jury, not call a witness to come in and testify about all the details of what happened with that, but just to establish that there are suspicious persons calls being made by the neighbors in the neighborhood, that there are extra patrols happening, and that there are extra watches happening in this neighborhood. And what we would intend to do is simply use the date or the nature of the call and the address it's associated with. And so those documents, we want to put them in. They're authenticated and they survive. We have the business record exception of the document. We have that certification by the custodian. They are now self-authenticating and they are business records, so they would be admissible on that certification alone. And then what we would do is just simply tender to the jury in our case, there was a call for suspicious person on this date at this residence. And if the state wants to go through them and disagree with that this suspicious person was resolved as irrelevant, then we certainly can do that. But we would simply want to establish that there are calls about suspicious persons in and around property, that there are requests for extra watch, there are requests and there are extra patrols being done, which establishes that this neighborhood is experiencing a high volume of crime, which is then being discussed amongst a lot of the neighbors, and we'll have testimony about that, which is also then being discussed with Travis McMichael, and he is also aware. He doesn't have to be aware of every call that's happened, every time 911 is called, but it is a fact that is relevant to this case, that this is a neighborhood that's experiencing a lot of crime and the police are focused on it. It would be consistent and it would corroborate a lot of the testimony that we've had. And so to the extent that it does corroborate that testimony and it establishes just very basic facts of what's happening in the neighborhood, we think it's relevant and it supports our defense of this neighborhood being essentially on edge and under attack. So I understand the nature of Ms. Dunikoski's objection in going in, but we're not intending to call all those witnesses to come testify. We're simply interested in the nature of the call and the time period of these calls.
Sounds like you're trying to characterize those two.
We're not. We're going to say suspicious person call made on this date by this residence. We've already had testimony about what a suspicious person call is. We've had testimony on extra patrol. We've had testimony on neighborhood patrol by Officer Rash. We simply want to corroborate that with these documents. We're not going to get into all the details of what that is. It's that people are dialing 911 consistently, starting in January, which we were made aware of by the state. Starting in January, we're not doing things like Citizens Assist. If that's included, that may just be, but we're really interested in neighborhood watch.
For example, Citizens Assist.
Yeah, that's not one that's really relevant. That could be somebody who fell down.
So, for example, I'm trying to figure out how you're not going to start getting into what these documents are. So you plan on asking Dial about this?
Well, Dial, we certainly could ask about his investigation and his understanding of what was happening in Satilla Shores and how he may have investigated that.
So how do you plan to use this?
When we present our case, we intend to say, Your Honor, at this time, we seek to admit defense exhibit, number, put it in the record. Then, at that time, if it's admitted, then I will say on January 1st, 2019, there was a neighborhood patrol that was conducted. On January 7th, 2019, there was another neighborhood patrol conducted. On January 30th, 19, there was a theft entering auto reported. On March 20th, 19, there was another neighborhood patrol. On March 23rd, 19, there was a suspicious person reported. On March 26th, 19, there was a neighborhood patrol. And go so on. And that's it. I want to establish that the citizens are calling and requesting police intervention. This is not a new subject to the case. This is one that has been discussed. But again, we want to corroborate what we've asked on cross-examination. So there's no unfair surprise. And we're not going to get into all of the details of it. Certainly the state, we can, if they want to go one by one, we can do that. But that's our intention.
And are you going to link this up to anything the defendants knew, or are you just going to say this is what was out there as far as this record?
This is what we're doing in our case in chief, just essentially and generally to try to respond to the court's question. We are calling residents of this neighborhood, residents who have experienced their own crime, residents who have participated in the discussions on the Facebook page to which Travis McMichael and his father and family had access and looked at. We will be linking that up through testimony that's relevant to Travis McMichael. And this corroborates essentially those witnesses and other people in the neighborhood who have experienced problems. These are public records, Judge.
Yeah, I understand.
Yeah, okay, all right.
Okay.
Yeah.
Anything for the other defendants?
Yes, Your Honor. Teresa, can you hear me here? I'll pop up there. Just to point out that when we began the trial, of course, we had the initial list that the state had provided. It became clear after the opening statement and several witnesses, beginning with Officer Duggan, that there was an attempt by the state to characterize through minimization what was going on in Satilla Shores from about October 2019 to February 2020. There was a question, can you describe the level of crime? They get their fair share, and the court is not going to recall this, I'm sure, but
I remember testimony about Baker 9,
and
what the officer's impression of the level of calls and all of that were.
Yes.
So that's why I'm wondering why this wasn't discussed with that officer, why that testimony wouldn't have been challenged.
Because there had been an attempt by the state, I believe it was Ms. Olivier doing Officer Duggan. So not much, she said, not much. And I objected, no, that's a characterization. And he stood for himself and said, yeah, their fair share.
There's more than Duggan, I thought.
But Duggan's not the Baker 9 man.
Please don't cut me off.
I didn't mean to do that. I'm sorry, I didn't hear you.
I'm just because I'm trying to work through this. I remember at least one, maybe more, officers that were asked about activity in Baker 9 and what their call volumes were and the types of calls that they were responding to.
Yes, and I agree with you in a general way. But the state has, in one portion of their case, attempting to minimize, and has said that there were 3 entering in autos. One of them was Travis's, and one burglary, which turned out to be not a burglary. Our position is, if you're living in a neighborhood where patrol cars are coming out to respond to these calls, whether or not it turns out to be something that was confirmed, whether or not a suspicious person was located, this raises, as we'll be able to show in the Facebook page, people's level of concern. So the question of the timing of all this and how we intend to introduce it and why now deals with, it is in a direct response to the state's desire to minimize what had been going on in the neighborhood, which the neighbors will, I think, directly refute.
Michelle.
On behalf of Defendant Bryan, I will adopt the response of the counsel for the co-defendants in this case. And really, there's one specific issue I want to address. I think I've noticed in the court that we sometimes feel like the red-headed stepchild sitting over there in the corner. And I've noted before that we tend not to get served with things from the co-defendants in this case. And for the record, I'm holding the document that Ms. Dunkowski was holding up earlier. I think this is the first time that I've seen it. Actually, I haven't read it yet. I guess there's a little bit of trust there. But I'm going to adopt it. And as far as discovery purposes, to the extent that's still a concern for the court, this is the first I have possession or knowledge of the document. This is the earliest opportunity that I could use it. And therefore, I think that there is no discovery issue there, because I would join the McMichael defendants in wishing to present this document in Defendant Bryan's case in chief. Thank you, Your Honor.
Final word from the state.
Thank you, Judge. I think Mr. Sheffield actually made my point for me. The document I served on them is the Spillman list. I attempted to get Parker Marcy to talk about it, if you'll recall. I asked him specifically, did I ask you to verify the Spillman list? I asked you to look at this list and pull up these various things, this burglary call and these entering auto calls, the few that were on the list of 126 over 14 months. And he was prepared to testify to that and to talk about them. They objected. They stopped the state from doing this and going into this. And at that...
I'd like to be heard on that afterwards.
And then after he goes, I'd like another chance to come back, because I never seem to be able to get the last word. But I would...
in court.
From the state.
Thank you, Judge. The list that I had Miss Batchelor, Lieutenant Batchelor, certify was served in discovery. And it was served in discovery back in, I think, the end of 2020. So everybody had that list and knew about that list. The anticipation would be that, of course, someone would testify to the number. I want to point out to the court a couple of really important things. In opening statement, Mr. Rubin got up here and said, Satilla Shores was a neighborhood on edge due to the crime. So what's the state supposed to do? We're supposed to, not address that issue? They brought it up in opening statement. It's been a theme. It's been a drumbeat with the defense constantly. This neighborhood's on edge. All these people are having, backyard conversations now electronically via Facebook. And everybody knows. Mr. Sheffield just told you the purpose for this. He just told you, we're going to argue the neighborhood was under attack. He just told you that's exactly what they want this evidence in for, to show that this neighborhood was under attack. The problem is unless I'm allowed to address that we got roommates that are having problems, the neighborhood's not under attack. We got somebody who thinks a car's not supposed to be there, and oh, lo and behold, it is supposed to be there. One of the guys on the green tab called up because his subcontractor showed up on the wrong day, and he was calling the police because the subcontractor wasn't supposed to be there. So this idea that the neighborhood is on edge, I mean, at that point, Your Honor, absolutely. If this is allowed in, I'm going to go through every single one of these with Dial so he can explain to the jury that this call came in and it was miscommunication. This call came in about some roommates. And the idea that Travis McMichael knew about some roommate disagreement inside a house, the idea that somebody called up and said, I can't find my credit card, and Travis McMichael knew all about that, I mean, it's ridiculous. The list that I provided to them, that Mr. Sheffield just said he would go through that list. He said he wanted to go ahead and do the date and the nature of the call. What I served on them, which Parker Marcy was going to talk about, was the nature and the date of the call. Now, he wants to add in the location of that call, which is why now he wants to tender all of these in. So, Judge, I guess it's a double-edged sword. If we're going to go down this route, then I'm going to go down it fully. I do have a problem with the fact that I don't recall anybody talking about what extra patrols were or extra watches were requested. I don't recall anyone testifying to what those things were. I don't think Officer Rash did, or how those things are initiated. And of course, none of this was discussed with any of the actual officers, such as Parker Marcy and Officer Rash, as to these calls. In fact, I think I asked Officer Rash about Rob Ray and the roommate thing, and he didn't know anything about it. So at this point, their argument is this high volume of calls. I guess the other argument they want to make is the neighborhood's under attack. Look at this high volume of calls we have. Therefore, that leads us to believe the neighborhood's under attack. Look at the extra patrols that were being initiated by officers. Therefore, this must be an entire neighborhood that's under attack. And none of it actually is relevant, because unless Travis McMichael knew that Officer Powers on November 11th at 9 o'clock in the morning initiated an extra patrol, what relevancy does it have to his state of mind? Because he doesn't know about any of these things. I mean, maybe he's going to go, yeah, I was totally tuned in. I knew every time an officer made while I was at work at Metz and Marine, I certainly knew these officers were doing these extra patrols. If he's going to testify to that, that's fine. But there's no connection between any of these things. So, Your Honor, we ask that this either, I guess, be completely excluded, or I guess that you allow the state to thoroughly ask Agent Dial about each and every single one of these, and we'll go through them one by one so the jury understands the nature of my subcontractor turned up on a wrong day. Hey, there's a car that's here. Oh, it turns out it's a miscommunication. Hey, there's suspicious people walking down the street. Oh, Mr. Bowie actually does live at that house. Our bad. We didn't mean to call 911. So I guess we either put it all in or we don't put anything in. Because just to go, here's the number of calls, so therefore this neighborhood was under attack, and here's the big sheaf of papers, that's unfair to the state. And so if we're going to do this game, the state's going to walk the jury through every single one of these calls. And by the way, in here there are police reports attached to these. So they're not just 911 CADs. There's actual police reports attached inside here with narratives and investigations. There's also citizen assists in here. So when Mr. Sheffield said, oh, we pulled the citizen assist out, that's not relevant, I immediately turned and found one that said citizen assist within here. Here's a copy of a police report right there attached to it. So, you know, and this is about accessing a hard drive by an officer. That's the kind of stuff that's included in this. We ask that it be excluded. Either we go down the road totally, or we don't go down the road at all. Thank you.
I don't want additional argument. You want to clarify the record?
Yes, please, Your Honor. Thank you. We haven't even offered this yet. We've just given her the stack of papers. She hasn't even tried to talk to us about this yet.
We're not offering it into evidence right now.
Let's do this then. I want the three things that were just referenced. I want to see what that stack of documents is.
Okay.
I want to see what was produced. There was a CAD report list that I understand was produced, and then there was another certified copy. I want to see what those three are.
Got it.
And I want to know when they were produced.
Okay. The list was produced to us in reciprocal discovery. So we'll give you a copy of that list.
Okay.
We intend to pull from, we printed off everything from that and just gave it to the state. We haven't even marked them or offered them into evidence yet. The state is a little premature on this because we have to pull the ones that we're going to use. We can do that.
No, I want to see what's produced because, as I understand it, we're either a day or two away from the end of the state's case in chief.
Yeah.
I want to know what was produced in discovery and what was just produced, and there were 3 documents that were referenced. I want to see them. I want to understand what they are,
Okay.
so that I have a way to cross-reference what we're talking about.
Perfect. And then to comply with just responding, Ms. Donikoski says it's a discovery violation.
This was provided to us by her.
Well, hold on a second. I just said I don't want argument. You said
It's
that
not-
there was something she said in the record that you needed
Yes.
to clarify.
This officer, the officer up here, was asked to look at the Spillman report and draw a conclusion about whether Ahmaud Arbery was responsible or identified with the thefts or burglaries. That's what we objected to. If you recall, we said this.
And I'll go back through notes and try to work through. But the dispute came up when he was specifically asked about burglaries in the neighborhood, and that was objected to because there were no certified records, and we couldn't get in. And the court wouldn't allow the way the state was going about it to get that in. I'll go back and look at it.
Okay.
But I appreciate you pointing it out.
Yeah, I disagree with that. But it was more about his conclusion and opinion of whether or not Ahmaud Arbery was involved. And we said this officer was not involved in those investigations, so he'll just be reading reports from other people, which is all hearsay, and making a determination if Arbery was involved.
And we stopped there, and I said, certified, as long as we get certified. So now we're certified, and you want to present to the jury
Well, that's
yourself
important.
the certified report, correct?
What we want to present is we don't want to, it's not going to go out. What we want to do is we want to establish essentially that list plus the address.
All right. Like I said,
Of the
if I-
only relevant ones, Your Honor, sorry. Just of the relevant ones, the suspicious person, extra watch, and neighborhood patrol. Not so-and-so, hiding out, and it's a mistake. We don't want to
So-
present those.
So just so I'm clear, so what was produced to the state today then, it's actually a more narrow list.
It will become more narrow when we present it in our case in chief.
Okay. 2 things then. I want to see the 30 whatever documents.
I'm not sure I know what the third one is, Judge.
Well, there was
The list plus the stack.
plus some.
Oh, the certification.
Yeah.
Okay.
If I may, Your Honor, just because I need to clarify this.
Let me just finish my thought. And I also assume that based on this, there's going to be some discussion so that maybe this can be narrowed down even further, because we are, as I understood it, a day or 2 away at this point from where the state had intended to end its case in chief. And so if there's additional time and additional witnesses, I guess everybody needs to figure that out. And that's part of what the court needs to factor into all of this with these documents. I don't need a response to that. I just need the documents. We're belaboring the point at this point. And I indicated that state had the last word. I'd simply ask, you jumped up because you wanted to clarify the record.
Yeah.
I don't need additional argument.
Great.
Okay. Thank you.
Thank you.
So, Your Honor, I'm going to give you the state's official certified copy that I received from Lieutenant Batchelor on November 10th. This is the copy I've received. I tabbed it as best I could at 68. And so that we know, the best I can do is right now is pull this up. And the thing is, Judge, this was served on us by the defense. This certified copy that I made was just a certified copy of what they had served on me via the McMichaels Discovery Store and Go. It was due October 30th. It's dated October 29th. It says all calls list from 1/1/2019. So they actually got it from Cherie Batchelor back then, served it on us. I was using it as their exhibit with Parker Marcy. I'd send it to him going, look, the defense gave us this. Please verify it. Please pull it up on Spillman. I can take a photo shot of this if you want to see it so that you know what I'm talking about as far as the discovery goes.
As much information as I can get on what the documents are that we're talking about would be helpful.
I will take a screenshot of it and email it to an appropriate person that I will be given later, right?
Yes.
I will do that right now.
Why don't you use the same email you generally use from my office.
Yes, sir.
While she's doing that, without taking up any more additional time, Your Honor, may I also say that the actual reports could have just been used for impeachment purposes if the state had used Agent Dial to talk, as we were concerned she would, talk about the slow amount of crime in Satilla Shores by just using the Spillman list. We did not have to provide any of that to the state. We could have simply used those reports if we felt the agent was not being accurate or complete in the summarization of those reports. So the issue of discovery violation does not seem to apply here. The issue of the state now wanting to go into all of these reports suggests to me that what we were concerned about is actually what the state intended to do, and that is to say, look at this couple-page printout of Spillman. Just tell us really about a couple of instances where you had to go out there. And so it's a good thing that we pulled the actual reports to keep everyone on the right page and accurate in an agent's summarization of a Spillman report for which he had no involvement.
There's a big difference between impeachment evidence and what I understand this was going to be presented as part of the defendant's case in chief, the way it's presented. That there's differences there.
Absolutely, but
Okay,
the first way it could have come in is that way.
But that's not what we're talking about, and Dial hasn't testified to. So that's not what was just presented to the court. So there's a couple different ways evidence can be used, that depending on the evidence of Agent Dial or any other officer that may have been out there that's already testified that was not impeached with this evidence. Yeah, there's a couple different ways, but I've got to look at the other part of this too, which is using the evidence in the way that was just described. So.
Certainly, and I just remind the court, there's two defendants here, though while we worked in concert in many ways, it is the position that we certainly could have used them in impeachment.
3 defendants.
2 defendants with respect to the presentation of the use of this evidence.
I just didn't want Mr. Goff to know that his argument went unheard by the court.
Your Honor, may I approach?
Yes.
And I have sent that email with the screenshot of the discovery.
All right. All right, we made it through one party and any preliminary matters. Anything from Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan?
Yes, Your Honor. I'm not sure that I would describe it as an invitation from the court yesterday, but this morning we did file a motion to prohibit any further conduct that may intimidate or influence jurors and otherwise interfere with a fair trial. The clerk has the original. I miscounted and did not make enough copies for the court to have a courtesy copy. It raises the same issues, perhaps with more authority than were raised previously, and the attached exhibits present the basis for the motion in more detail, perhaps, than had been provided the other day. And I think that given the nature of the issue, if the court's going to address it, it would be one that we addressed before we proceeded this morning. Certainly, if we're going to be documenting the individuals in the gallery for the rest of the trial, the sooner we start doing that, the better off we would be. Having said that, I also let the court know that, shocking as it may be, I desperately need a bathroom break. And I was going to suggest that perhaps the court would want to digest that motion and consider whether to allow any further argument about it at that time.
All right. Well, let's do this. Let's take a 10-minute recess, and then we will bring the jury back in. I understand the medical examiner is the next witness.
Correct, Judge.
All right. Let's get to the witness in 10 minutes.